return operations and its possible impact on the fundamental rights. This presentation is created solely for the purpose of online training on the fundamental rights closely connected with border guarding within the European Border and Coast Guard Agency's training framework. All text is taken from the course manual for Frontex Fundamental Rights Trainers, issued by the European Border and Coast Guard Agency in 2019. The creator of this presentation is one of the authors of the manual. The presentation shall be used for internal training purposes only. According to the Return Directive, return means the process of a third country national going back, whether in voluntary compliance with an obligation to return or enforced to his or her country of origin, a country of transit in accordance with EU or bilateral readmission agreements, or exceptionally, to another third country to which the third country national concerned voluntarily decides to return and in which he or she will be accepted. The national authorities may conduct the return in two procedures. First, removal, meaning the enforcement of the obligation to return, namely the physical transportation out of the member state. Second, voluntary departure, meaning compliance with the obligation to return within the time limit fixed for that purpose in the return decision. For the purpose of this course, the provisions on removal and the relevant joint operations are further referred to as forced return. The Return Directive emphasizes that, where there are no reasons to believe that this would undermine the purpose of a return procedure, a voluntary return should be preferred over a forced return, and a period for voluntary departure should be granted. An extension of the period for voluntary departure should be provided, when considered necessary, because of the specific circumstances of an individual case. In particular, Article 7 of the Return Directive specifies that a return decision must provide for an appropriate period for voluntary departure of between 7 and 30 days. EU member states may provide, in their national legislation, that such a period must be granted only following an application by the third country national concerned. In such a case, member states must inform the third country national concerned of the possibility of submitting such an application. The time period should also not exclude the possibility of third country nationals concerned leaving earlier. Where necessary, the period for voluntary departure can be extended by an appropriate period on the decision of authorities, taking into account the specific circumstances of the individual case, such as the length of stay, the existence of children attending school and the existence of other family and social links. Certain obligations aimed at avoiding the risk of absconding, such as regular reporting to the authorities, the deposit of an adequate financial guarantee, submission of documents and the obligation to stay at a certain place, may be imposed for the duration of the period for voluntary departure. If there is a risk of absconding, an application for a legal stay has been dismissed as manifestly unfounded or fraudulent, or the person concerned poses a risk to public policy, public security or national security, member states may refrain from granting a period for voluntary departure or may grant a period shorter than 7 days. By providing financial assistance to migrants voluntarily returning to their country of origin, the authorities can provide migrants with the means to establish economic activity in their home country, thereby ensuring that the return was sustainable. Voluntary return schemes help migrants who are lacking a legal status in any country to return to their country of origin. Voluntary departure is preferable to forced return, and it presents far fewer risks with respect to human rights. Therefore, it is recommended that host states promote voluntary return, in particular by affording the returnee a reasonable amount of time to voluntarily comply with the removal order, offering practical assistance, such as incentives or covering transport costs, and providing complete information to the returnee, in a language he or she can understand, about the existing programs of voluntary return, especially those of the IOM and other similar organizations, which the host states have been encouraged to set up and to develop. Although voluntary return is always a preferable option, the returnee might be forcibly returned by air, land or sea. The framework for the core provisions on the forceful return is provided in the Returns Directive. Forced return procedures may also result from non-compliance with the time frame given in the return decision or the return order issued in line with the relevant EU and national legislation. The Frontex Code of Conduct sets out principles and rules that should guide the behavior of all persons participating in Frontex activities, namely Frontex staff, officers of border guard services of a member state and any other staff. It aims to ensure the rule of law, respect, protection, fulfillment and promotion of fundamental rights, with a particular focus on accompanied and unaccompanied children and other vulnerable persons, including those seeking international protection. It includes the obligation of referral to national authorities competent to receive asylum requests. The Frontex Code of Conduct is complemented by the Code of Conduct for Return Operations and Return Interventions coordinated or organized by Frontex, which sets out common principles and the main procedures to be observed during such operations and interventions. This Code of Conduct sets out essential rules in relation to the general principles of fundamental rights, the limits on the use of coercive measures, the presence of medical personnel during operations and also the vital role of fundamental rights monitors in ensuring operational compliance with fundamental rights. All participants in activities coordinated by Frontex are required to maintain the highest standards of integrity, ethical conduct, professionalism and respect for fundamental rights. While taking part in activities coordinated by the agency, they are required to comply with international law, EU law and the national law of the organizing member state or the transit country, including their fundamental rights provisions. In cases of a violation of any of these legal provisions in the course of a return, the member state of each return operation or return intervention participant must sanction its staff with appropriate measures, in accordance with its national law. Moreover, all persons participating in Frontex coordinated activities are required to report any incidents involving suspected or alleged violations of fundamental rights or the Frontex codes of conduct. All persons involved in activities coordinated by Frontex are expected to treat each person with courtesy, respect and due consideration and in accordance with the principle of non-discrimination. The specific needs of vulnerable groups or vulnerable persons, such as children, persons with disabilities, elderly people, pregnant women, single parents with minor children and persons who have been subject to torture, rape or other serious forms of psychological, physical or sexual violence, as well as persons with a serious health condition, mental disabilities or any other vulnerabilities, as defined in the EU law, should be taken into account and addressed during all phases of the operation. Before conducting the return operation, a set of preparatory measures are required to ensure that the fundamental rights of the person to be returned are guaranteed and respected. Some of the relevant operational measures are presented further. Seating plan. The organizing member state must provide seats for not only escorts and returnees but also medical staff, interpreters, monitors and Frontex representatives. Seats for observers and external representatives should be also considered. Consideration should be given to families with children, families should not be separated on board, people in need of special care, etc. Food and beverages. Cultural and religious considerations should be taken into account when providing food and drink to returnees during return operations, as well as the presence of babies or young children on board. To avoid discrimination, no distinction should be made between the food served to return operations or return interventions participants and the food served to returnees. The type of food and quantity should be sufficient to cover the needs of the persons on board and during the length of the flight. Fitness to travel and medical examinations. Collection of information must be followed by an analysis and the dissemination to the appropriate entities. The countries implementing a return decision must ensure that all returnees are in an appropriate state of health to travel. The returnees are to be removed only as long as they are fit to travel at the time of the flight. The medical doctor on board must be informed as soon as possible, prior to a joint return flight, about any pre-existing medical condition affecting a returnee and/or medical treatment required, to ensure required medicines and medical equipment. Only medical staff have access to the medical information of the persons to be returned.